My name is Nancy Barnes, and I would like to welcome you to PlusHR webinar on 6 key considerations when hiring a new employee. PlusHR are based in central London and are a team of friendly CIPD-qualified HR experts who specialise in providing practical HR and recruitment support to UK businesses. We offer a range of services that help businesses of all sizes handle their HR, recruit top talent, and develop their team. This webinar is intended to provide practical assistance and support in navigating the 6 key areas that often get missed or applied incorrectly when bringing on a new employee. To start our journey, I would first like to stop at our first port of call, which is the use of best practice. It is the degree of measure given to the actions a business applies in a specific situation that goes beyond the minimum requirements. So, for example, best practice would be the practice of always advertising vacancies internally before it goes to an external source such as the local newspaper. Best practice, however, is not always a practicable or even commercially viable solution for many businesses because of the cost or resourcing implications. Or it may be simply that the business is not aware of what the industry norm is or too afraid to apply best practice. The reason why it should be a consideration when recruiting a new employee is that best practice can help pave the way to ensure that you avoid any potentially litigious claims on grounds of discrimination and will help place your company in a positive light with prospective candidates. After all, we all strive to be the best, so applying best practice shouldn't be the reserve of the big companies, but we should try and keep it as a consideration where practicably achievable. So, in some of the slides, I have added a best practice tip, which I hope you will find useful. When a business has decided to recruit, it is vital that the advert placed online or via paper meets the legal requirements in terms of salary offered and wording used. It is also important to note that litigious claims can and have been used by prospective candidates when it comes to applying for jobs where they feel there is clearly a case of discrimination being applied. In an old case, a gentleman forwarded the same resume, albeit change of address and name, for the same role with the same employer advertising. He was bemused to find that his female alter ego was offered an interview, but not himself. Needless to say, the employer could not justify nor defend why one sex was selected and not the other, and unfortunately for them, the tribunal agreed, and the claimant won on grounds of sex discrimination, a very costly recruitment exercise. So, it is important when you shortlist the applications you receive, you are prepared to be able to justify your selection in case you need to. It is therefore prudent, where possible, to review the shortlist with another member of staff and arrange a mix of suitable applicants. During the recruitment stage, one frequent question that I'm always asked is the use of criminal background checks and medical questionnaires. There are only certain professions and activities that require a criminal check. It is not enough to say that because they work with money, they should be checked, because that in itself is illegal. So I would always seek further advice from a regulatory body or from ourselves if you're unsure. On the use of medical questionnaires inside an application form, they should only be used for specific professions and can be justified. Other than those exempt professions, if you really feel the need to ask medical questions, it should be justifiable, reasonable, and upon an offer of employment. You will also need to be aware that there are laws in place that deter employers from not employing those at a disadvantage, either physically or mentally, to even those who have spent time in custodial sentences. So, if you have been aware of these conditions and wish to withdraw an offer, you will need a very good legal reason as to why. When you have found your ideal candidate, it is advisable to always follow up in writing what was discussed and agreed. From experience, I have managed a few upset candidates who misinterpreted the verbal offer made, such as the one case where the candidate thought the annual salary offered was the monthly salary and was surprised about his first pay packet. Also, a word to the wise: don't make promises about bonuses, commission, or on-target earnings if you are not 110% sure about the mechanics of the application of these benefits. Because remember that a verbal agreement can be just as good as a contract, especially when there is an absence of a written contract. When we make an offer to a candidate, there is an expectation as to what each side will deliver. The employee will be expected to devote their time, effort, and attention to the job in hand in return for an agreed sum of money. How we communicate this to the candidate can vary. In a verbal offer, it is prudent to follow up with an offer letter. This written agreement can act as a holding letter before the contract is issued, so to allow the candidate to resign from their current position. Or, the offer letter can be used to accompany the contract. It is common that the offer letter identifies the periphery requirements or additional information that the incumbent contract may be subject to. For example, the offer of employment is subject to the candidate passing background checks or proving they have an important credential. The contract of employment can itself be a single document, otherwise known as the Statement of Terms and Conditions, or it can be a multitude of documents otherwise known as the Contract of Employment. With a contract, it seeks to combine the offer letter, the terms and conditions of employment, or any other contractual conditions, such as non-disclosure agreements, or for pharmacies, this might be the confidentiality clause. A very important point to note is that a contract is generally considered for life, and it should not include any term that can be construed as ambiguous. It just needs to be fit for purpose. Where there is a single document known as a Statement of Terms and Conditions, this is usually fairly short and will just include the minimum requirement as set out in the Employment Rights Act 1996. It is not uncommon for most small businesses to use a statement, especially where the nature of the work does not require the use of Post Termination Clauses or is subject to a specific condition of employment. In all cases, an employer should issue a Statement of Terms and Conditions as the minimum within 8 weeks of an employee or worker commencing. To this day, I still work with companies that wish to change a contract for one reason or another, and it doesn't matter the size, the principle is the same. Essentially, you cannot make a change to a contract unilaterally, as this can be grounds for a legal claim. This is not to say you as the employer cannot make a request for a change in the contract. What it means is that you should consider asking and informing the employee as to why you want to change their contract. Making changes bilaterally is always better. For those who are not afforded that luxury for one reason or another, making a unilateral change may be the only way, but you should always seek further advice. In any event, deciding what type of contract or statement is best for your business is a matter of fit, resources, time, and the nature of your industry. Ensuring you have the right contract for your business needs is as important as recruiting the right people for your business. It is more so important now, given that recent changes to the employment law, which came into effect in January 2016, that afforded protection to employees to zero-hour workers by way of making it illegal for employers to apply exclusivity clauses in their contracts. In the use of zero-hour contracts, the media portrays them as, unfortunately, negative. This is far from the truth, and their existence in the right work environments is an ideal solution to managing your workforce and payroll costs. As a short introduction to those who have never had need to use them, a 0-hour contract does not promise the employee or worker a minimum number of hours of work in a set time frame. This zero expectation allows an employer to reduce or increase or place at zero the hours of work an employee undertakes. If you are wondering why on earth an employer would resort to this, it is to allow a more cost-effective means to manage your workforce, payroll, or overhead costs. In a seasonal or customer-reliant business, where the work is dependent on external factors, such as the number of customers, a 0-hour contract can benefit both the employer and employee, by way of allowing the employer to employ people and also giving the freedom to the employee to decline work or change the number of hours worked in a given period. In our table, the standard type of contracts most of you are probably familiar with are full and part-time status. However, if you are in a business whereby you have the need to employ staff but are unable to afford them the freedom to decline work, like in the use of a 0-hour contract, then the use of the variable hours is another type of contract that allows flexibility to a workforce. Likewise, the use of a seasonal contract normally has a shelf life and is generally used for work in the hotel and tourism sectors. The use of casual is the term given to the ad hoc need for workers. So, a typical example is where you need to have staff come in and work on an ad hoc basis, such as to do event work or to help at a one-off function. Importantly, it is not for a long-term, ongoing basis. The use of term time contracts are generally issued to those who only work during school term time. This may not be the educators themselves, but also if you have cleaners that only work in educational establishments during term time. If you are in the business of being a management agency, then you should be using a third-party contract for those working on site. This is a special contract that makes a clear distinction in identifying who is the employer and who is the third-party agent, which is an important feature when it comes down to who is in control of the employee from a legal perspective. Apprentice or trainee contracts are very exceptional, in that the law is clear about the protection afforded to an indentured apprentice. If you are considering the use of an apprentice or trainee, then it would be useful to seek further advice about which contract to use, because using the wrong one may lead to a very expensive and difficult exit of a work relationship. The foundations of a contract are built using implied, expressed, and incorporated and statutory terms. This is in addition to the window dressing of what other clauses an employer wishes to apply. The most important term, and one that takes precedent over implied, is the express term. In a contract, if a term has been specifically mentioned and agreed by both parties at the time, the contract is considered made. An express term is generally in writing, and the most common one is the salary or pay. It is always best to have express terms in writing so that there is no misunderstanding. At the end of the slide, you will note there is reference to some recent case law. Judgments made in case law do have an effect on shaping the overall employment law, so the reasons why these specific cases are special is that they potentially have the power to change the playing field in how holiday pay is calculated, to now include non-guarantee and regular overtime. For many of you that have employees who do regular overtime, you should be taking an interest in how this develops, as it may mean that the holiday pay could be calculated over the average of an actual salary paid, as opposed to what is said and paid contractually. An implied term is simply an agreement created by actions of the parties involved, but it is neither written nor spoken. An implied term can override an express term if it is reasonable, notorious, and certain. An example is the simple tea break. There are some contracts that stay silent about the duration of tea breaks, but if a business has for the last 10 years had a mid-morning break, then for an employer to suddenly remove this without the proper consultation can lead the employer into hot water, let alone some very upset individuals. In some instances, some implied terms are stated by business efficacy, so without it the contract does not function properly, i.e., there is an exception that in order to be paid, the employee is expected to undertake the job in hand. Another building block is the use of an incorporated term. An incorporate term is a term which is so critical to the business that it needs to be inside the employment contract. Remember that the employment contract shouldn't be as long as War and Peace. It just needs to identify the expectations from both parties. So refrain from adding all but the most essential items. A typical incorporated term, such as in the case of the care industry, may be the need to maintain a specific qualification. Incorporated terms can also come from handbooks or from collective agreements, such as those businesses with trade unions or work councils. In these cases, it is common to see that if there is an agreed collective workforce agreement about the times of work, then this will form part of an employee's contractual work conditions. A statutory term is one that is governed by law, such as ensuring that the salary being offered meets the national minimum wage or living wage. On this note, it is important to remember that the calculation of the national minimum or living wage is calculated using a pay reference period. So, for those who have received a fixed wage per week or month, it is always good to double check that their wage is no less than the national minimum or living wage rate. When all is said and done, with what is or is not inside a contract, I always advocate the use of a company handbook to work alongside the terms and conditions of employment. This non-contractual document is the ideal place to put all the company rules, policies and procedures which are likely to change for whatever reason. Remember, if you put them inside, within the terms and conditions of employment, then you are at risk of not being able to change them without the employee agreement in the first instance. It would be remiss of me not to include a slide about the use of Post Termination Clauses, as these have been increasingly popular inside many contracts of employment. Typically, Post Termination Clauses, such as non-competition, non-solicitation, non-dealing or non-poaching, provides a detailed description of what an employee can or cannot do after employment ceases. This is very different to a confidentiality clause, which is normally effective during the employment life as well as at the end. Post-termination clauses must be reasonable, relevant, and specific. So, for example, the blanket use of these clauses being applied to all staff members in your business without due care and thought may not be seen by a tribunal as being applied with consideration. After all, is your receptionist really going to have the same gravitas as your top salesperson with your clients and make them leave your business? Most likely not, in which case installing a non-solicitation or poaching clause inside a receptionist contract may not be relevant. That is not to say you are forbidden to have a post-termination clause in there, but it may be a clause that is relevant and, most importantly, reasonable. The most common types of post-termination clauses are non-competition covenants. These place restrictions on an employee to prevent them working for a direct competitor in a similar position. Non-solicitation covenants. These prevent employees from contacting customers, suppliers, and other contacts of their former employer with the intention of poaching their business. Non-dealing covenants. These prevent employees from having any direct contact with their former employer's clients, customers, or suppliers, even if the customer, supplier, or client initiated the contact in the first place. Non-poaching covenants. These are similar to non-solicitation covenants, but are specifically designed to stop former employees from poaching other employees from their previous company. So this effectively stops an ex-employee taking someone with them when they leave. In some cases, there are clauses which restrict where an employee or how an employee can work. Known as geographical parameters, these prevent the employee in some instances from setting up their own business in direct competition to their former employer within a certain area. For example, not within 50 miles of the employer's registered business address. Obviously, if the former employer's address is in a highly populated centre, such as London, the restriction may be unreasonable and thereby legally challenged. Restrictive covenants are incredibly complex, and for both employers and employees, challenging them can be very time-consuming and costly. It is important that employers understand what they want to achieve with a restrictive covenant, and that the terms and conditions they're laying out are fair to the employee, whilst at the same time protecting their own business interests. Employees should be absolutely sure that before they sign an agreement, any restrictive covenants are fair, reasonable, and justified. What have we learnt? We have identified that it is important to take into consideration 1. Best practice, as this can assist and support your new employee. In the very least, it can lend itself to being a positive consideration for your business. 2. When you are recruiting, you read applications carefully and be prepared to justify your shortlist and selection of candidates for interview. 3. When making an offer, it is always best to follow up in writing soon after. 4. The various types of contracts and how important it is to apply the right one for your business needs. 5. An understanding of what an employment contract is made up of. 6. The application and consideration for using Post Termination Clauses. Thank you for attending today's webinar. We hope you found this useful.